we'll go ahead and get started. Just a minute. Now we've got the YouTube going, so we'll get started. So my name is Alan Lilly. I'm the presiding hearing officer of the State Water Board's Administrative Hearings Office. This hearing is in the court's reference to the State Water Board and the State Water Board's assignment to the Administrative Hearings Office in City of Marina versus RMC Lonestar, Monterey County Superior Court number 20 CV 001387. Today is Monday, October 24, 2022, and it's now 9:06 a.m. So before I continue, I'll ask for appearances. I'll start first of all with California American Water Company. If somebody can just tell me who's here for CalAm, that would be great.
Good morning, Bob Moore here for CalAm. From Allen Mack's law firm, yes.
Okay, and who else do we have?
Good morning. My name is Michael Betts, also on behalf of California American Water. Good morning.
Good morning. What's Mr. Osias? You have to go off mute so we can hear you.
I apologize. David Osias. David Osias for CalAm.
Robert Donlin, Allison Schneider for CalAm.
And Catherine Horning with California American Water.
All right. Good morning to all of you. For Marina Coast Water District.
Good morning, Mr. Lilly. James Markman from Marina Coast Water District.
All right.
Good morning, Mr. Lilly. Kyle Bouchard from Marina Coast Water District.
Good morning.
Good morning. Ruth Stoner Muzine, Friedman and Springwater, also from Marina Coast Water District.
Good morning. Howard Wilkins, Remy Moose Manley from Marina Coast Water.
Good morning, Christina Berglund, Remy Moose Manley from Marina Coast Water District.
All right. Well, good morning to all of you. And then for City of
James Neudecker for RMC Pacific Materials.
Oh, okay. I was just going to ask. Thank you, Mr. Neudecker. You beat me to it. You're a little faster than I am on a Monday morning, but that's fine. And then we have for City, who is here this morning for City of Marina?
Good morning, Skip Spalding for City of Marina.
And good morning, Mr. Lilly. Larissa Meisenheimer, also for the City of Marina.
All right. Well, good morning to all of you. I think that's everybody who's on board this morning. From my office, we have Nicole Mullen and Kyle Woldridge, ably running the video as always. And I always want to repeat this, but I'm so glad to have them on my team. I could not possibly run these videos without their assistance. So I appreciate that very much. So let me tell you where I am, and then we can discuss where we're going. I received an email. I'll just tell you what I have and make sure I have everything. I received an email from Mr. Wilkins' assistant, Mr. Ramirez, on Friday afternoon at 3:10 p.m. It came into our office and was forwarded to me, discussing some issues that have come up with the deposition of one of CalAm's expert witnesses, Peter Leffler. And then our office received on Friday afternoon, although I didn't read it till this morning, an email at 5:17 from Mr. Moore, and then an email yesterday evening. Sorry to have to work Sunday evening, Ms. Meisenheimer, but 6:11 p.m. From Ms. Meisenheimer. So first of all, is that all of the correspondence we have regarding the present issue? And
I think so.
Okay, great. Thank you. And let me just tell you what I did. I actually, even though I didn't log on to my computer to get these emails yesterday evening, I was actually researching this. And as far as I can tell, and this is the history I have, I received a joint pre-hearing conference statement from City of Marina and Marina Coast Water District on May 17th, which on page 3 proposed that said the AHO here, we recommend that the AHO hearing officer set certain procedures associated with witnesses' depositions In particular, we believe that the AHO hearing officer should, one, set a 7-hour time limit for each deposition, and two, require that each party or group of parties taking the deposition of an expert witness pay the billing rates of that expert for the time spent in the deposition. Following that, we did have a pre-hearing conference. Let's see, I forget what date that was. Looks like it was May 25th, and I issued a pre-hearing conference order on June 1st, which, among other things, set the deposition or set the calendar for the depositions and said each deposition shall not exceed 7 hours, basically tracking that. And I believe there was some discussion during the pre-hearing conference, and all the attorneys agreed to the 7-hour time limit. Of course, the big issue that's come up now is what does 7 hours mean, but which we'll get to. But first of all, do I have that right? Was there any other correspondence regarding the history of the 7-hour time limit?
I don't believe so. I certainly don't remember if it was.
Well,
maybe Michael does. I don't know.
Mr. Betts, anything else?
No.
Okay. So, and I do believe it was discussed during the pre-hearing conference on May 25th, and all of you agreed, number one, to have the depositions, and number two, to the 7-hour time limit. And I guess the other thing that's important is either then or at a subsequent status conference or pre-hearing conference, I pointed out that I did not think I had the authority to issue orders, the typical types of orders like orders compelling production, sanctions, and so forth, that the trial judge has, because the trial judge had not assigned that authority to me. And I put that in at least one of the orders, I think the June 1st order. More recently, the issue came up with Mr. Crooks's deposition, and at our pre-hearing conference last week, I can't remember who, but an attorney for either Marina Coast or City of Marina basically argued that even though they agreed I didn't have the authority to issue general discovery orders, including, incidentally, not relevant here, but side point, issues regarding reimbursement of expert witness fees, which had been raised in the pre-hearing conference statement, but I just don't think I have the authority to enter any orders on those issues. But one of them argued, well, we do think you have the authority to prohibit a witness from testifying if that witness and the attorneys for the party that witness is working for have not complied with the deposition rule or schedule and rules. And I agreed. And that's why my order from last Friday, my pre-hearing conference order stated that Mr. Crooks would not be able to testify unless he was made available for deposition. So with that, I think that's the background leading to Friday afternoon. Before we get to Friday afternoon, I just want to go one step at a time here so I can make sure I don't miss anything. Is there anything else that's relevant background getting to Friday afternoon?
Yes, there are.
Okay, Mr. Moore, go ahead. Thank you.
Okay. Well, first off,
not the issue of whether it's 7 hours running time or total time. We'll get to that in a minute.
Okay, I understand. We're asking questions, and they were asking questions. We're going through the questions. We said at one point, I believe, are you sticking where's that question relate to the questions by the judge? I got back from Mr. Wilkins, I think, that it's none of our business, basically. 1 second, if I can, Your Honor.
Okay, well, I mean, so maybe we can put this in a bin. This is separate from time limits, an issue regarding the scope of the depositions. I think is what you're alluding to. Is that correct?
Another thing I'm alluding to, and this is probably a good time as any to talk about it, is under California law, and we're dealing under California law. I see they cited California statutes, California law. In California law, if you have a beef in discovery, You've got to meet and confer. That means talking reasonably to the other side to see if you could get an answer agreeable. And that's always the rule. And if you don't do it, you don't get heard. When this started, I offered, we had an hour and a half left. And I offered, why don't we split it? That is,
Okay.
You'll have 45 minutes left. We're not taking the deposition. But if we have a beef over an hour and 45 minutes, you take the 45 minutes. What I got, I'm sorry, I thought I had this in here.
Okay, Mr. Moore, I think you're getting into the argument. I wanted to do that, I'm going to come back to you.
Okay. Yeah.
I just want, and normally I read the submissions very carefully, and I've read them quickly here. But just in case I've missed anything, I want to give each of you an opportunity to summarize. And you don't need to read it all again. I certainly have read everything that's been stated, but just I'll just give everyone an opportunity for a brief summary. So, Mr. Wilkins, you submitted the email that started this discussion. So is there anything you would like to emphasize that either is in your email or an additional point that's relevant to the issue of how we calculate 7 hours for Mr. Leffler?
Assuming it's limited to just the 7-hour question, no. I mean, I guess the only thing on the 7-hour issue itself is the fact that when Mr. Spalding mentioned 7 hours running time in his admonitions, I never interpreted it to mean 7 hours, including breaks or lunch, nor did Mr. Spalding, to my knowledge, and I never agreed to that. And I don't think I can unilaterally change the rules that you set for this. So that's my opinion, that I never agreed to that. And there was never a discussion about what 7 hours meant at that point in time. So, and obviously there's some back and forth, and I don't want to repeat what's in the email. So happy to answer any questions about it, but that's all I have.
All right, thank you. All right, so I'm going to go in chronological order here, even though it does mean a back and forth on argument. So, Mr. Moore, I'm going to come to you now, and I have at least briefly read your email, including the deposition transcript excerpt. But with that, I interrupted you before, but go ahead. Is there anything else you would like to say?
Yes, they were asking questions at that point, really beyond the scope of what this case is all about. And they also had said in the beginning, it was running time. I know what running time is. Our whole team knows what running time is. And so we thought running time. Well, running time was done at 8 hours, I think, or 7 hours. And we brought it up and said, look, you're going beyond the time limits of this deposition. And on top of that, we had a colloquy going back and forth. I said at that time, look, why don't we agree that we can split it? You get 45 minutes more, and it ends in 6 hours and 15 minutes, not your full seven as far as you are concerned. And given the fact that in California, of course, you don't get anything unless you meet and confer. Let me read a couple sentences here. I said, are you getting a little far from the questions asked by the judge at this case? I can't find anything on the list that you present question relates to. Can you answer the question, please? He's talking to my client. Can you point to what question this question is answering? Next, I don't think I have to. And I'm not asking if he'll answer the question, please. Why don't you think you have a right to? I mean, there is a question about questions asked by a judge. And you're saying you don't have to look at those questions before you speak? You ask questions? He says, I don't have to justify my question. I said, well,
incidentally, Mr. Moore, I don't know who you mean by he, so you might want to tell me.
Mr. Wilkins, sorry.
Okay.
And I said, well, thank you for doing it, though, if you would. I just don't see it. And I think there's going to be some point we'll stop this and do something else. And Mr. Wilkins said, I don't have time to continue to have this conversation with you about this. If you must know, I will stay. I hope you'll stop this interrogation. This is meet and confer under California law, and it's necessary. So I want to show you that, and when we first said it, we think that these 7 hours has been run off. Both of them, Mr. Wilkins and Mr. I asked him, didn't you say in the beginning of this deposition that it was running time? They both denied it. So my partner said, why don't you look back at the record? And sure enough, that's exactly what they said. We take that to mean, and everyone I've spoken to takes that to mean that's a running clock, basically. And I don't think it's controversial that it's a running clock, but almost more importantly, we tried to make an offer on our meet and confer offers by saying, let's split it. They never got back to that. All we got was snarly answers to it. And then we were there and so we come back and talking to another issue really, which is our fairness. We come back and say, okay, we're not going to, you don't have to agree. We're going to give you 30 minutes more so you can catch up and do things maybe you didn't anticipate. So we give them 30 minutes more. Now, not only did we meet and confer, not only were we fair in what we're doing, I don't have any doubt that running time is you turn off the turn off the stops. That's what I think, anyone that looks at this, I'm not speaking for you, Ms. Lee, would come to the same conclusion. But we did meet and confer. In fact, we pushed them to meet and confer. And we asked them, and what do we get is nothing. No counter offer, nothing. And just angry from the other side. So if we're going to use the Code of Civil Procedure and they keep pushing that we do, they have to meet and confer. So that's basically the argument. Okay.
All right. Thank you, Mr. Moore. Ms. Meisenheimer, you filed the last email that I've received. So is there anything you would like to add to your email?
Sure. I think on the 7-hour issue, just to take a step back for a moment and sort of out of the weeds of sort of who did what at the deposition, it is very typical in California to have a 7-hour deposition. I think we put in front of you the statute that governs it. The notes are very clear that the 7 hours does not include breaks. It's never included breaks. That's not the way people typically do depositions. And I think that there was a seizing upon a statement that was made at the beginning of a deposition. From our perspective, it clearly runtime is the time you're running on the record. And so I think this is a challenging situation where we're trying to get up to speed on a very difficult and late disclosed model. And so we do need the time with these witnesses to be able to examine them to better understand it. And so I think from our perspective, it's really important that we're able to use the full 7 hours.
And while we're on that question, Ms. Meisenheimer, has the deposition of Johnson Ye occurred?
It started. So Johnson Ye's deposition started on Friday morning. We have about 5 hours and 15 minutes of time on the record. Opposing counsel for Cal-Am had a personal issue, which he raised with us. We all agreed that we would break the deposition at the time he needed to leave and resume Monday morning. And so we have just resumed. We did about 20 minutes on the record before we hopped over to this hearing. But I do have some concern about what positions are going to be taken at Mr. Ye's deposition. We would like to make sure that we have the remaining, hour and a half that's left.
Yeah,
Mr. Lee,
I'm not surprised it might come up or not. I'll say it probably will come up rather than getting into double negatives. Somebody else wanted to say something?
sure. This is Michael Betts. At the appropriate point, can I respond to Ms. Meisenheimer, of course, when she's done, last night's email?
Are you finished, Ms. Meisenheimer?
So I've addressed the 7-hour issue. Do you want to handle that first before we get into the document production issues?
I think it's probably good if you just mention that now as well, since that's I think was in your email was the first one in this chain that talked about that. So go ahead and do that. And then Mr. Betts, I'll circle back to you.
Great. Yeah, so we have served a series of notices of deposition. As you've probably seen, the deposition dates have moved over time, but the document requests have been identical. So Cal-Am has had these document requests for quite some time. When we sat down to do the deposition and began questioning witnesses, it was very clear that the witnesses had not been asked to produce the categories of documents that we had sought. And, some of them, I understand there may be arguments as to relevance, but it included really key materials. I mean, we had an expert who said calibration is the key to determining the reliability of a groundwater model. But then he said he hadn't turned over any of the evidence, emails, et cetera, about what they actually did to calibrate and what happened.
Which witness was that?
That's Johnson Ye.
Okay, go ahead. Keep going. Excuse me.
Yeah, Mr. Ye, when asked about if he turned over his client file, he only named a few things. He said he had not turned over email with his colleague, Lauren Wicks, and that's who he did most of the work on the groundwater model with. He didn't turn over his time records, his engagement. A lot of those things that you really need to understand and kick the tires of a groundwater model. Turning to Mr. Durbin, it became very clear he'd never even seen the document requests. He hadn't turned over his file. He hadn't turned over certain portions of his email. And I have in the email that I sent is sort of a rundown, sort of with quotations of what's not there. But it came up, for example, recharge. In the Weiss report, it says it's very sensitive to recharge. The amount of recharge you put in impacts the ocean water percentage. And when we asked Mr. Durbin, do you know how much recharge you put in? He said, no, not as I sit here, or something to that effect. And we asked him, where would you go to look? He said, in my files. We said, have those been turned over? He said, no. So it just became apparent that there were problems that from our perspective are going to seriously impede our ability to fully understand and kick the tires on these models.
Okay. All right. So Mr. Betts, we'll turn to you. Please go ahead.
Thank you. I appreciate your time. I start with a problem with the number of these hearings, meaning these impromptu emergency hearings. And what I just heard from Mrs. Meisenheimer, we got an email, as you aptly noticed, at sometime very late Sunday evening, much less after the Niners lost. But putting that aside, I don't think that's a proper forum. These jump up, make a claim day before a hearing when they're going to Mr. Moore's point. This has never even been discussed. It's not even like the 7 hour where there was a discussion on the record. Not once has someone said in any deposition, we think we need more documents. You didn't give us enough. This pops up. And unfortunately, I think you've been prejudiced by some of this, of statements they say when we don't have an opportunity to respond. This happened in a prior motion in limine, the 7 hour rule that came up on Friday, and seeing some of the colloquy of what has taken place there. And
excuse me, Mr. Betts, for the prior motions in limine, I thought I allowed full briefings of those. Is there something that you thought was unfair about those?
Thank you. I appreciate you bringing that up. Yes. So the notion that they brought up asking for a surrebuttal case, you'll remember it got brought up. We did not have the opportunity to oppose. I think there was a hearing the day before you left. And I'm not fighting with that. I'm not disagreeing with it, but it's just another instance of something's come up. There's a lot of misrepresentations, I got to tell you. And what they told you.
And just so we're clear on the surrebuttal, I didn't grant their motion or deny it or rule on it. I just said we'll address that issue later. So I don't think I prejudiced Cal-Am on that issue. I basically said we'll have to deal with that later. But anyway, please proceed.
In part, I think the hearing's gotten chopped up a little bit, for us going first and when parties go. And I raised this issue last time. I do think, and I'm not revisiting this issue. I'm making a point, though, that these last minute half representations to you, and I'm going to demonstrate in a few minutes that a lot of this has been false. But it started back on that one. You're right. The issue of the surrebuttal will be discussed. Maybe I improperly coined it. But comments about what information they had, I think infected that hearing. What they've told you we've done, I think it's infected. And I'll bring it back to this one, is giving a Sunday night email on something that's never been discussed for an issue which you aptly said a while ago on May 6th, that if parties have discovery motions, that they shall file a motion with the court. Well, if motions are filed, people get to respond to it. And I'm not ducking the issue. I want to get back to it. But I think there's been a lot of, cheap shots, saying things that have happened that just haven't. And these emails, let me go right to that issue. The emails and documents, much of this has nothing to do with the 8 questions asked or Mr. Ye's work or Mr. Durbin's work. And we took the position months ago that we're not going to go back and produce documents from a decade ago, which they spent all sorts of time asking our witnesses about. We've said we're not revisiting. what the State Water Board has ruled on, prior models, what the CPUC has ruled on twice, and making this a fishing expedition over the last decade and a half of what these folks have done. And we've made that position clear since the inception and never heard that there was a problem back. As it relates to this proceeding, we have given them everything that they've wanted as fast as we can. We gave the output models, the predictive models, the input models, all of which you can see what work was done. So to say that they don't know what our client has done because they didn't get an engagement letter, that's the argument I just heard, or billing records, that's just not fair and it's not true. And by the way, they chose to proceed with the depositions with the information they had that we gave them months ago in our direct testimony, our attachments. As I said, when they wanted more models, we've given it to them. And we've had a real problem on the other side getting it to them. No, we haven't brought it to your attention, and that tit for tat, I'm not making that argument. My point is we've given them everything that they've asked for. As it relates to Mr. Durbin, again, this will tie into some of the substance. He went till 2 a.m, and a lot of the questions, if you saw the full deposition transcripts, have still nothing to do with 8 hours. They're asking about what alternatives are there out there for water pumping, or what did you do 10 years ago? And we've spent more than half these depositions, if not more, that talking about nothing that has to do with these proceedings. And it goes to the document request. So you're correct. 10 years ago, documents they don't get, but they do have, Mr. Lilly, everything related to their direct opinions, their rebuttal opinions, the work that they've done. When they ask us for the models, they've gotten it. So in sum, I'm responding to this late night, and there's a much bigger picture. I wish I could show you the transcript for all these. I wish I could show you what we've given to them. And I wish I could show you on the other side what they haven't given to us. We got 8 questions to deal with, and we've dealt with everything but that in these depositions. So that's my humble response, Mr. Lilly, to the late night email issue. There's probably a few more.
Well, you don't need to be humble about it. That's very clear. I appreciate your time. All right. It looks, Mr. Wilkins, you started it, so we'll let you finish it. Go ahead. I'm being a little bit facetious, but your email Friday afternoon started this current round of discussion. So please go ahead.
I do want to address, the contention that information other than what was in the direct testimony and the current 2022 model is all that we should be able to ask questions about. It's not proper to ask questions about their prior modeling efforts. And I think it's important, and we'll obviously demonstrate this when we have a trial in our opinion, and they'll potentially disagree, but I think you're entitled to hear both theories about what happened here. And I will offer proof that Mr. Durbin said that his current SVSM model is based in large part on prior modeling efforts, including without getting into the very technical details, the meshes and other things. And so when I ask questions about his prior model, they relate to how the current model is set up and what assumptions are in it. And I believe that is entirely appropriate. And you heard from Mr. Moore that I would not meet and confer with him on the record about questions. There were constant speaking objections in these depositions, coaching of witnesses. Those are things that we would need to bring to the trial court's attention. I don't want to, but hearing that I was quick or wouldn't talk to them at all is just improper. And we can make an offer of proof with the deposition transcript if you need be about why these questions are relevant to the current proceedings. And Mr. Moore, just for the record, when we did do the Leffler deposition, was off camera and speaking to the witness, and the court reporter asked him to please state for the record what he was speaking to the witness about. And he told the court reporter, I don't want you to hear that. I mean, there has been a large number of irregularities with these depositions, in my opinion. But that is not an issue we're trying to bring in front of you. But yes, we were frustrated. And the idea that I have to justify every question and have a meeting confer on it, when that's cutting into our record time, to ask questions of the witness, does get rather frustrating after a while. And as I said, we will present our case. But the idea that we can only ask questions about what's in their current testimony and not about the underlying model, I think is just simply wrong. And so that is my rebuttal to what was said right now about our questioning.
Okay, I want to wrap this up. I know you all have depositions to take, but Mr. Moore, you're I do think you're allowed to respond on the specific argument that Mr. Wilkins just made about you coaching some witness. I assume it was Mr. Durbin. Is that, let me just back up. Which witness was it, Mr. Wilkins?
Loeffler.
So, Mr. Moore, you may respond about the allegation from Mr. Wilkins that you were coaching Mr. Loeffler off the record. Please go ahead.
That is absolute nonsense. When he said I turned to my right, David Osias was at my right, and every once in a while I turned to David Osias, ask a really quiet question, and see what he wrote back. There's nothing wrong with that. If I'm coaching a witness who was sitting over here, how the hell would I do it if I'm turning in this direction? That never happened. And I got to tell you, our objections because it's not just they're saying what happened. It is the questions being asked. What you and a board has to do before they send it back to the Superior Court judge. I will tell you, I don't know what was on his mind when he wrote out these questions. I don't, and no one does.
I certainly don't. Go ahead.
I mean, I think that he did for some reason, and the questions are the questions. What they're trying to do, I think, is fight the battle of whether or not this project is viable again. Like I've done in front of the PUC twice, we've done in front of the board. All this is coming up again. And they're fighting a battle different than what's being asked of them. That's another reason why, if they want relief, they've got to go back to the trial court and get relief from the trial court who wrote the questions. I think, and I think right now, when you're looking at this level, they haven't done it, and they have to do it, and they have to meet and confer. I mean, he says we don't have to meet and confer. He doesn't know California law, but cites California.
No. Wait, let's not get too active. I'm sure Mr. Wilkins is aware of the meet and confer requirement under California discovery law. So don't go that far. But you were doing well, but let's try to avoid the personal attacks.
Okay.
We all know that rule. We've all been doing this for a long time.
Right. Well, certainly
some of us longer than others. Yeah. Go ahead.
There wasn't a word back from them other than we're not going to stop, or why are you asking me these questions? There are a whole bunch of things that was pretty indicative. They were not going to meet and confer, did not meet and confer. And we came back, and that's what we come back with. Okay, we'll give you extra 30 minutes. It wasn't agreed to. The reason why we gave an extra 30 minutes was because we didn't want them to be in a position where they didn't have a chance to do something they really wanted to do. So we couldn't stop it right then. And then I get in their report that somehow they weren't given the right to use this letter that we claimed was attorney-client privilege. When we said no, it was 30 minutes later. And if they wanted to use it, they had 30 minutes to use it. To argue now that they lost something because they didn't take their chance at 30 minutes, I think is, anyway, I think that's it. Thank you.
Okay, thank you all. I'll just say you're all experienced and professional attorneys, and I'm not questioning that. You're also all very vigorous advocates, and it sometimes makes for conflict, but I'm not surprised. You're all obviously experienced and doing good work here. So let's sort of try to get beyond that as far as if there are any personal attacks or anything like that. Let me tell you where I'm coming from, because that's probably relevant to going forward. First of all, we are getting close to the start of the hearing. I do want to start the hearing on Wednesday. And the main reason is, we've grappled with this before, but if I lose these hearing days, it's just a long time before we can have additional hearing days. That's just sort of because we have so many people involved with different calendars. So I want to proceed. And as far as if that means that people don't have time to meet and confer during a deposition about deposition questions, I think considering the short time between the depositions and the start of the hearing, you should just let the questions go forward. We're not, as long as we're not talking privilege, you'll probably spend more time arguing whether a question is reasonably calculated to lead to the discovery of admissible evidence, which I'm pretty sure is the standard here, versus just letting the witness answer the question. So let's try to get through that. So anyway, let me just tell you I'm sorry if I'm a little bit rambling this morning. I didn't have a chance to organize all my thoughts since I just heard a lot of yours. First of all, on the 7 hours, I think it's pretty darn clear that that was not spelled out clearly in any of the papers that I recited, including my order, because I didn't know this was going to become an issue. But I think, from my read of Code of Civil Procedure 2025.290, in particular, subdivision A says 7 hours of total testimony. So I do agree with Mr. Wilkins. If that was the model for the proposal in the status conference statement or pre-hearing conference statement that ended up in my order, I think that's reasonably interpreted to mean 7 hours of total testimony. It seems pretty clear the 7 hours probably came from this statute. So I agree with Marina Coast and City Marina. 7 hours means 7 hours of testimony, and I don't know what running clock means. Mr. Moore, you're the former football player. I look at running clock to mean when the clock is running, not time for timeouts or halftime or so forth. And if that's a bad analogy, I apologize. But
I did go to sports with running clock. And
okay.
And so that's my authority at this point in time.
All right. Well, anyway,
So
let's not go down that path. But I think
no.
Let me keep going here. Well, we could spend 7 hours arguing about what 7 hours means. I think total testimony is pretty clear. That means 7 hours of when the people are in the deposition asking questions and the court reporter is taking down the transcript. And of course, if there's a long colloquy about objections, potentially that doesn't include that's not included in the 7 hours of testimony, but hopefully we don't have to get into that. So with that, my view is go ahead, Mr. Moore.
I'm sorry.
I shouldn't have raised anything about football. Now you're going to think you have to respond.
No, I'm not going to talk about football, I promise.
Good.
I'm not arguing with anything that said it's in the statute. It's in the statute. I know the statute. I've probably taken 1,000 depositions or been in 1,000 depositions. But this was an announcement that it's a running clock. That's not in the statute. That's a definition of a different kind of deposition. It's a different. He's describing what it was, and that, in my mind, it certainly clearly says you've got a running clock. It doesn't stop.
Okay. I look at the statute. The statute is not directly controlling here. I look at the statute for guidance to what the parties meant when they proposed and agreed to 7 hours, and when I put that in my order. And yes, there are disputes back and forth, but I think the best interpretation of 7 hours is 7 hours total testimony, tracking the statute. So that's what my ruling is. If Mr. Leffler is going to testify starting at the hearing that starts on Wednesday, Callahan has to produce him for a total of 7 hours of actual testimony time during his deposition. And that will be true for Mr. Ye as well. My understanding is Mr. Durbin's deposition is done, so we don't have to address that with him. So that's that ruling, and I hope you can wrap that up. It sounds like you're going forward. You obviously have multiple attorneys for each party, so you can presumably do parallel depositions. So I hope you can wrap that all up before Wednesday. And again, I'm sorry this is coming down to the wire. I certainly don't want to start pointing blame one way or another, but as I've explained to you, if I'm going to get this going and have some semblance of trying to meet the court's admonitions of getting my work done timely, I need to go forward with the hearing now, and that's why I'm doing that. So that's that. Now, as far as the other issues that Ms. Meisenheimer raised, Mr. Betts, I agree with you. And I'm not accusing Mrs. Meisenheimer of doing anything improper. We're coming up against depositions in the start of the hearing, so I think she did what she thought she had to do. But I certainly agree with you. You need to get a response before I issue, or you need to have an opportunity to give a response before I issue a ruling on that. So let me just say where I'm going on this. I understand you all, have your clients' interests and you're advocating for those and representing your clients. My goal at the end of the day is to get into the details of the testimony and the modeling to the extent necessary so that I and my colleagues, particularly the technical staff, can understand enough of the technical aspects of the modeling. And I think the main model that seems to now be before us is the 2022 model. I want to say North Marina something groundwater model. If I'm sorry, I got the wrong acronym, I apologize, but you know what I mean. I want to know at the end of the day where the parties agree, and most importantly, where they disagree on the modeling assumptions and data inputs, and what differences those disagreements make on the modeling results. I hope that's fairly clear, and I think you can understand that's what I want. And as I've said before, it's not a game. I need to get to that bottom line. I think we'll have the hearing. Some of these issues are going to come up on cross-examination of these technical witnesses. Some may come up on my questions or my staff's questions of these witnesses. And I'll be upfront with you right now. We may have to go to another round of hearings. I already told you, I think in January or February, and it was actually now January, March, and I put some dates for you to reserve on your calendars in the order I sent out on Friday. There are going to be some questions that my technical staff has that we're going to want to ask the witnesses. And again, this isn't a game of, you had your chance, now it's over. This is getting to the bottom line. The court wants me and the State Water Board to get into enough detail so we can figure out what's going on. And as I said before, ultimately what I think I care about, I know I care about, and I think this is right, is where are the difference in the assumptions that went into the modeling, whether it's input files or model assumptions, how do those manifest themselves in differences in output? And I don't know how many there are, but there may be some. Now, I do know something about, I've read Mr. Durbin's description of his new Salinas Valley groundwater model. And I'll just say, to the extent it builds on prior modeling work he did, again, I'm sorry, Mr. Betts, you haven't had a chance to respond to this yet, but that sure seems to me to be questions reasonably calculated to lead to the discovery of admissible evidence. I mean, it may or may not be that there's a problem, but that if he used that prior model to develop his new model, that appears to be relevant background information. Now, having said that, either Mr. Moore or Mr. Betts, you said this is not a proceeding to test the overall viability of the project, and I agree with you on that. This is a proceeding for me to answer the 8 questions and sub-questions that the court sent to the State Water Board. So what I see, and another thing, again, if I'm a little disorganized, I apologize. But I was reading Code of Civil Procedure 2025.290, and I noticed that subdivision B2 says that this section with the 7-hour limit does not apply at all to expert witness depots conducted pursuant to sections 2034.210 to 2034.310. Now, I understand we haven't followed those statutes here yet. There hasn't been the formal expert designation process that's done in civil when there's a civil trial and so forth. But it certainly does indicate a recognition from the legislature that for complex expert witness testimony, there may be a need to delve into that more. So I'm just telling you all right now, I want you to finish the 7 hours of each deposition that you are largely done with before Wednesday, if these witnesses are going to testify. And then at that point, let's have the hearing, and I want to find out whether I think there are areas that need further explanation. I don't want to, Mr. Durbin's been doing groundwater modeling according to his testimony for 50 years, and I certainly don't think we need to get into all of that. But if there's some relevant background we may need to get into that. So I would like those depots to finish with, as I say, 7 hours of testimony time per witness maximum. We'll start the hearing. We'll have cross-examination, which I hope can be focused. I mean, that's one of the other interests of mine in having full depositions, is so your cross-examination questions can be more focused. That's one of the purposes of depots. So I hope that will work here. And then my staff and I will ask our questions to the extent we can, and then we'll see where we are. I hate to say it, but I think it's pretty likely that there are going to be further questions, and these witnesses are going to need to come back at some point, particularly, after we've heard the other party's witnesses. So that's where we are, and whether that means there has to be additional discovery that's focused, we'll see. Anyway, that's a little bit of a rambling statement and order, and I apologize for that. But does anybody have any questions about that going forward? Mr. Wilkins, go ahead.
It's not really a question about your order. It's more a question about your timeframes for cross. You indicate that, I'm not going to go through all of them, that for Marina Coast, we have 2 hours to cross-examine Cal American's witnesses. And my question is that 2 hours to cross-examine all 4 witnesses? Or is that 2 hours to cross each witness?
I think the order is pretty clear. That's 2 hours total for all witnesses. I think I used the word total in the order.
That's what I thought, and that's what we thought. But we noticed that they have 2 hours to cross our 2 witnesses here, and then presumably they're going to get another 2 hours to cross our 2 witnesses in the server rebuttal hearing. So they're getting a total of 4 hours to cross-examine for our 4 witnesses, whereas we're only getting 2 hours to cross-examine their 4 witnesses, and that just seemed to be slightly unfair to us.
Okay, well, let's see. I'm not going to change that order now. I understand your point. Let's see where we are. I wish I didn't have to impose any limits on cross-examination, because it's just a stress point for all of us. But in my experience, in most of the hearings I've held, cross-examination has a way of droning on and on and on without producing useful information. So that's why I've imposed time limits. You're all very experienced and qualified attorneys, and I hope you will take this to heart and look. Whoever's conducting the cross-examination, I hope you will be able to get to the point and make your points. And if that also includes basically saying you think there's an information gap in what the witness has produced versus what may be reasonably calculated to lead to the discovery of admissible evidence, you can bring that up during your cross-ex and point that out. Of course, the other side can respond, and we'll deal with that. But I put the 2 hours there because I hope that that's how it can be done. But if you can, whoever's doing the cross-ex can demonstrate that there are topics that need to be covered efficiently, and it's going to take more than 2 hours, then I will allow more time. I'll just tell you that. I hate to say that, because I know that means this can expand a lot, but that's my plan going forward. So, Mr. Osias, your hand is up. Go ahead.
Thank you, Mr. Lilly. Just for you to remember, it's 2 hours for the district and additional 2 hours for the city. They've been splitting.
Yes, that makes, I can do that math. That makes 4 total.
Right. Now, but I have a question, and I think it's the simplest question you'll get today.
Good.
You have a 1 p.m. deadline today for slides that someone may want to use in an opening statement. And my question is, if you were going to use a slide that was identical to one that's, say, in the summary slides, do you need to resubmit it?
The answer is yes. And if the 1 p.m. deadline, if you all want that to be delayed, we can do that. But here's what I want, Mr. Osias. It is a simple question. I'll try to give a simple answer. I'd like to have one file that has all the slides that the attorney wants to use in the opening statement, because then my staff can go next slide, next slide, next slide, next slide. The way you were talking about it, we have to pull up some other file and get a slide from that, and that just takes more time. And it's, my staff is very fast, but these are big files and it takes a while for them to upload and so forth. So that's why I want to do it that way. So having said that, is that going to be, is the 1 p.m. and the reason I wanted 1 p.m. today is so that my staff and I can get all this stuff uploaded so we're ready to go. But we could wait until tomorrow morning if that is critical. So I'll ask you first. Is 1 p.m. today going to be a problem with that? But I want all the slides the attorney is using in one file.
Since Mr. Moore will be giving the opening statement and he's going to be possibly in depots, I assume the extra time would be helpful, but I don't know whether he intends to use slides. So I defer.
All right, Mr. Moore, are you going to use slides and do you want more time for the opening statement slides?
Yes and yes.
All right, so I hadn't focused on this. I mean, I didn't know last week that you were going to be doing depots today, so that's why I put that in. So we'll make that 9 a.m. No, that's a little harsh. Let's make it, I just want to give us time to get everything uploaded, but presumably we're just moving a file over. So we'll change that deadline. I'm not going to issue a new written order, so write this down. Deadline for slides for attorney opening statements for the Wednesday hearing is changed to Tuesday, October 25, 1 p.m. And the way you do that, as before, upload them to your FTP folder because these are large and they may not email well, and send the AHO an email with CCs to everyone on the service list when you've done that, so we know to go to the right folder to download them. And then we're going to download those and post them. I asked you just to make them exhibit numbers. So when your email, just say what exhibit number you have listed it as, and then we will post those with your other exhibits. As I said in my order, I think I want to have them be exhibit numbers so we can keep track of them and so we can put them in your exhibit folder. They won't be admitted into evidence because they're based on attorney statements and attorneys are not testifying under oath. But that's the way I want to do that. Mr. Markman, something I've said has caused you to have a question. Go ahead.
I'll ask the same simple question from our point of view. So
go ahead.
For our opening statements, both the water district and the city, we would prefer to submit them a day before we got to that point rather than by tomorrow, because we're going to defer our openings until just before our testimony. So would it be
okay? That's a reasonable question and a simple one. Let me tell you my thoughts on that, and that actually brings up something that Mr. Moore and Mr. Osias and Mr. Betts raised last week, and that is their firm's annual, I don't know what you call it, a retreat or something, but some important firm meeting. These are my thoughts. I would like to finish the Cal-Am witnesses in 2 days. That's probably more than the hours. You add up the hours. That's assuming we have some more hours. But if we can finish them by the end of the day on Thursday, which is October 27, then I will not hold the hearing on Friday, October 28th. I didn't know all this last Wednesday. I've now read over all the summary slides from the witnesses, so I have a little better handle on how long this is going to take. That would give us 3.5 days next week, because we do have a site visit built in there, which is going to eat up 1.5 days of the 5 days. But that would give us 3.5 days for Marina Coast witnesses and City of Marina's witnesses, which I think will be sufficient. However, if we do not finish the Cal-Am witnesses by the end of the day on Thursday, then I will continue with that hearing on Friday. So, but anyway, it does mean a target for starting Marina Coast and City of Marina's case next Monday, a week from today, which is Halloween, October 31st. So, Mr. Markman, your deadline for Marina Coast and City of Marina opening statement slides will be Friday, October 28th, 1 p.m. And that, I don't know, you may want to tweak them based on the Cal-Am testimony.
possibly not? We're not even sure we'll use them, Mr. Lilly.
Yeah, well, and you're busy, I know. And I did say, since you're doing half your case now and half your case in December, that's why I put 10 minutes for that. So I hope you can limit it to that. I mean,
Yes.
I've read the opening briefs. I have a pretty good idea of what's going on here. But that's my plan for that. So
Thank you.
that, again, if I can do that without issuing another order, my staff is getting pretty busy.
No, that's fine. We have it, Your Honor. Mr. Lilly, thank you.
Yeah, okay. So
Mr.
that's
Lilly,
where,
one other
Go ahead,
cleanup
excuse
issue,
me.
my apologies. We were supposed to upload exhibits by 1 p.m. today from depositions, but of course those are continuing. Would it work to have us upload them by 1 p.m. tomorrow instead?
yeah, yes,
Great, thank you.
October 27. Yeah, I'd rather you get them all and not have to revise them for depot exhibits. My staff's going to be really busy tomorrow afternoon. And you may say, well, it's not that big of a deal, but it takes time to move all these files, I can assure you. But let's do that. Hopefully you'll have all the depot exhibits. And then when do you think you will have the depot transcripts? That's going to be an issue. And I'm sorry about this, but it's almost like whenever the hearing started, it was almost inevitable this was going to come up. Not my fault, but it's almost inevitable it's going to come up this way. But when will you have the depot transcripts to transmit to me so I can upload those?
We can do that on a rolling basis. We have Mr. Durbin's deposition. It typically takes, we're getting an expedited 2-day final. So it may not be until Wednesday that we have the depositions that are continuing today.
Okay, so Ms. Meisenheimer, you're in charge of this since you spoke. So I'd like you to upload what you can or work with other parties to upload what they can, but do that all by Tuesday at 1 p.m., what you have. And if you can, when you do that, send me an AHO an email and of course CC the other parties and list in that email which depot transcripts you have uploaded and the schedule for uploading the other ones. So we'll be able to keep track of that. And that way we'll be able to get them as soon as we can so that you can use them as necessary during the cross-examination.
Sure, no
Is
problem.
that okay with you? All right, we've got 2 more hands, electronic hands now. Mr. Newdecker, go ahead.
Thank you, Mr. Lilly. 2 issues. First, in the order that you submitted, I think last Thursday or Friday, there's a section on the order of proceeding.
Yes.
There was not a notation in there for RMC to give an opening statement. I won't have a long one, but I would like to say a little something. As you know, we didn't submit any direct testimony, any exhibits, but I will have cross-examination of at least one City of Marina witness. If possible, I'd like to defer my opening until maybe after the City of Marina's opening. If I were to give it Wednesday after Cal-Am, it would be forgotten by the time the witness testifies.
Okay, because Marina's going to give its opening statement and then you're going to want to cross-ex, so you want to wait to do that. I understand.
That would be my preference if it's okay with you.
Yeah, that's fair. So why don't we have, and your cross-ex will be just of the City of Marina witness, Mr. Long?
I believe so, yes.
Okay, so let's do this. My plan is hopefully we will get there by next Monday for Marina Coast to go forward. I'm not sure exactly how long that'll take. We have a full day on Monday and half a day on Tuesday, and then we have a travel time and site visit on Wednesday. So I don't know when we'll get to Marina. I think Marina's testimony is going to go fairly quickly. But whenever we have City of Marina's opening statement, then you can give your opening statement right after that before the witness questions start for them. And if I forget, you remind me, okay?
Thank you. And then one other issue.
Let me just write this down. Sorry, if I don't write it down, I won't remember it.
No, that's fine. After
City of Marina opening statement. Yeah, and you know, now I'm going to get into trouble, but I'm going to say this anyway. I read over Mr. Long's summary, and I mean, he goes through a lot of background documents and basically authenticates them. And that's fine. I think the background is important and certainly something we'll probably want to put into our proposed our report. But I hope you don't all think you need to spend a lot of time cross-examining Mr. Long on the meaning of documents. I mean, the PUC adopted an order or someone else, there was an agreement that was signed by the parties, and he can authenticate those, but I don't know how productive it's going to be to ask him to try to interpret a lot of agreements that were signed before he was even there. So I'll just throw that out as an admonition. I guess that's mainly to you, Mr. Newdecker, if that's okay, but
Yeah,
keep that in mind.
Yeah, I mean, I'm not going to ask him anything about authenticating documents. I'm not going to ask him for legal opinions. And frankly, my cross will be less than 10 minutes, I imagine. So
Okay.
we'll get through it. The second issue relates to the site visit. And it looks like there's going to be an additional order issued on that with some details. I'm told I'll need the number of people that will be attending the site visit, at least on the CEMEX property, to make sure that there's sufficient protective gear available for everybody and for security purposes. At this point, I don't believe I need names. I think I just need the number of people showing up at CEMEX on the day of the site visit.
Well, that's certainly a reasonable request, and obviously we fully respect any safety concerns that CEMEX may have and want to follow those. So if you can all just do this, one attorney per party, just send an email to the AHO and let's do this we're going to want to get that notice of site visit out. So, and this, you should be able to do this now so same deadline, tomorrow, October 25, 1 p.m. Each party send an email to the AHO. I'm writing this down with CCs to the service list. And list, I think it's just as well to list who is going to attend. I think we might as well all know that. You presumably know that by now. And then we'll have numbers and we can get those to Mr. Newdecker. And also, if you can, number of vehicles. You didn't ask for that, but I suspect CEMEX may want to know that as well, which is a fair thing to know. So just names of people for site visit and number of vehicles. Can everybody do that? Is there any problem with that? And of course, I will do that. I can tell you right now from my staff, it's me, Mr. Woldridge, and Ms. Graziano will be our people attending the site visit, but we'll confirm that as well. Okay, so those are fair questions, Mr. Newdecker. And as I say, we're just going to be driving around, so I hope there won't be serious safety concerns, but we fully respect and will comply with any CEMEX safety concerns.
I'll share details as I have them. Right now, that's the extent of the details that I have, that I need numbers to make sure that safety gear is available. Yeah. Okay, thank you very much. And I appreciate your taking the lead on working with your client on that. Okay, you can take your electronic hand down, and Mr. Wilkins, your electronic hand is up. Go ahead.
Just on the deposition transcripts.
Okay.
We have not met and confirmed about Mr. Loeffler's availability, and I know I'm in an all-day settlement conference here in my office starting this afternoon. So I'm guessing his deposition will go forward at some point tomorrow. And knowing the way transcripts work, we're not likely to have a transcript for Mr. Loeffler before the hearing starts. We may have the first 6 hours, almost 6 hours, but we won't have a complete transcript, just so you know.
Okay, well, for that, and please coordinate as necessary with Ms. Meisenheimer, who got stuck with coordinating depot transcript file. I'm sorry, Ms. Meisenheimer, it's just that you raised the issue, and so I asked you to follow up, and I appreciate you doing that. But Mr. Wilkins, why don't you go ahead and make arrangements to have 2 separate transcripts, one for the part of Mr. Loeffler's depot that was last week, so you can get that one processed and work with Ms. Meisenheimer. Either one of you obviously can upload that and let us know. So do that as soon as you can, and then just have the court reporter prepare a separate transcript for the completion of his depot. I think that'll be better. That will have hopefully most of it up by the time the hearing starts, and then we'll add the rest as soon as we can.
All right, thank you.
Okay, and again, I apologize for cracking the whip on all this, but I said before why I want to keep going forward with the hearing. I did delay it a week from when it was originally scheduled to start. I will remind you back in September. So, Mr. Osias, your electronic hand is up. Go ahead.
Well, I'm just responding so Mr. Wilkins and everyone else, all the number of lawyers who represent the district and the city will know that I had been informed on Friday that Mr. Loeffler was totally out of pocket for a personal matter that he did not want to explain to me on Tuesday. So I've written him with the result of this hearing while we are sitting here asking when he's available, and I will share that. But if Mr. Wilkins is tied up today, then somebody else for the district or the city may need to finish the hour that you granted.
Okay. And I certainly thank you for letting us know. You all have, each party has multiple attorneys. I know it's hard sometimes to tag team for that for depositions, but one way or another, you need to work this out so that his depot and Mr. Ye's depot are completed by the end of the day tomorrow. And I really don't want to get involved in that if I don't have to. So you're all professionals. Please try to show some kind of reasonableness in this so we can get this through. I think it's only a few hours for each one of those two deponents. And those are the only two we have left, right?
No, we have Ian Crooks too.
Okay, well, all right.
We started him at 8:30 this morning, broke for this hearing. We told him to come back at 10 o'clock. Obviously, we're not going to get back on 10 o'clock.
I'm going to finish this as soon as I can so you can get back to that.
Okay, well, I'm just telling everybody on the top line, 10 o'clock's not going to work. We should start at 10:30, I think, or
yeah, we're just about done here. So that's certainly due notice to everybody on this call.
Yeah.
Okay, is everything more or less clear? Sorry if this is a little garbled. Since these are just moving some deadlines, I'm not going to issue another written order unless you think you really need it. I think we've got these all written down. So let's go ahead that way. And as I say, we're going to have the hearing and we'll see where we are as whether further hearing days or discovery are necessary after that. One last question for Mr. Wilkins. Go ahead.
I am just letting you know that I am concerned that given that we already have two depositions going this morning, Mr. Crooks and Mr. Loeffler, and Mr. Ye, and that there's no way I can move this settlement conference. I have 10 people coming to my office for this thing. I don't know that we're going to be capable of doing the deposition this afternoon. We have multiple attorneys, admittedly, but I was the one who prepared for Mr. Loeffler. Maybe we can take it tonight, but I don't think it's possible for me to hand over this deposition to someone on my team because their deponent is not available tomorrow. So I am concerned, and it did appear that you were saying, Mr. Lilly, that someone else is going to have to finish the Loeffler deposition who wasn't there for it and doesn't know the questions and didn't prep for it. And I'm not sure that is what you said, but I am very concerned that is the implication that you've left.
Okay, well, thank you for bringing that up. Were you the only attorney for Marina Coast who was at the Loeffler deposition last week?
I believe I was the only one who was there for the full time, but I could be wrong about that.
Okay, well, certainly, the last thing we want is to get into arguments about what questioning had already been covered if some new attorney is taking over. So, okay, well, I want you to do the best you can. Maybe Mr. Loeffler has some accommodation for tomorrow. And we're talking, I think, 1 hour here. So I would hope he could have some accommodation. If worse comes to worse, and you can't do the hour any sooner, we may have to have him do the hour while the rest of us are in the site visit next week, and have Mr. Loeffler's depot for that hour, and then bring him back for some follow-up questions on Thursday and Friday.
He has called me in response to my email, so I will know soon and circulate the information.
Okay, you all know how to do conference calls, so to use the jargon of the statute, meet and confer and try to work this out. But one way or another, let's get this done and let's go forward. Okay, if there's nothing else, I don't see any other electronic or real hands up. So I'm going to close this so you can all get back to your depositions, and I will see you all electronically at 9 a.m. on Wednesday, and look forward to the filings from Ms. Meisenheimer and potentially others with the exhibits and depot transcripts and opening statements, all of which now are due tomorrow at 1 p.m., except for the Marina Coast and City Marina slide decks, which are due Friday at 1 p.m. Have I got all the deadlines right? And is anything else for today? All right. Thank you all very much. Please try to show some leeway and understanding so we can get through this. As I say, we may have another round of depots and questioning. So the more you can cover in this round, the better it's going to be for everybody. Thank you and have a good day.
Thank you.
Thank you.
Thank you.
Thank you.